Sean asked this question: how to avoid giving away ownership of intellectual property while promoting yourself or getting a prototype or product made. And this does happen because oftentimes, in order to take your idea to the world, you're going to need help. It's very, very rare that one creator has enough knowledge to market their product and get buyers and things like that. They usually have to bring in helpers. And this is an opportunity to do that thing that I said before, don't do, and that is to create an accidental partnership. When two people shake hands metaphorically or actually with the intent to profit, then they've created a partnership and they might not have meant to. And an accidental partnership in that case causes unlimited liability, which is not good. And so what we want to have is we want to have a clear contract saying this is what's going to happen. And so if you are doing an agreement to produce or publish a product, I actually answered that one in a previous AMA as well. In fact, it was Samuel, the person who asked the previous question, who asked about it. And so an agreement, and I did go through in the video, create to tell you all the different things that are going to be in that agreement, but it basically sets rights. You have the right to this, you have the right to that, you do not have the right for this. And also, too, something very important in that agreement is that it basically says that we're not making a partnership. One of the things that I know some people care about, and I happen to know that Sean would care about this, is that you can also specify what causes that partnership, that arrangement to end. And so it is possible that you might want that to be a perpetual thing. And so, for example, let's just say that you've created a textbook and all you want to do is write and teach. You don't want to worry about that. Ideally, get a check in the mail each month. Great. You can do that. And it's common to work with a book publisher that gives them something like a perpetual agreement to act on your behalf. And depending on when you enter this agreement, it might be limited to a couple dozen years, and then it has to be renewed. But the way that you avoid giving away ownership of intellectual property is to have a contract. And so that could be a publishing agreement, or it could be some other kind of agreement, a marketing agreement or manufacturing agreement. There's different terms for it. This is a good time to call a lawyer because we will look over that for you. We've worked with artists to have their products manufactured or mass produced. We've looked at those agreements. We always find things that need some explanation. Those contracts can be difficult to understand. And oftentimes what happens is you actually have intellectual property from two different parties coming together. So for example, you might have a person who's created something, and then another party who has a system or process that they use to bring these to market. And so this person wants to keep rights to what they've created. This party wants to keep rights to their systems that they've developed. And so there's kind of this sharing agreement that says, well, I've got this and I'm going to let you use it, but you don't get to keep it. So those can be kind of complicated. It's best to talk to a lawyer.